welcome everyone to this webinar, and thank you all, first of all, of course, for attending. Thank you very much to the panelists for this interesting discussion that we're going to have. Thank you also to the Georgetown International Arbitration Society for co-sponsoring this program with us, the ICDR Young and International, or YNI. I am Rafael Carmona. I'm with the ICDR. And I just want to take one moment to say, if you're interested in our activities and initiatives, please join us as a YNI associate. You can go to our website, ICDR Young and International, and you'll see there a form to join as a YNI associate. And you'll also be able to find there recordings of previous webinars that we've organized. But you can also, as an alternative, join our LinkedIn group. We're very active in LinkedIn. So if you look for us, ICDR Young and International, you'll be able to find our group. We'll post also all of our initiatives there, and you'll be able to keep informed of any upcoming programs. And so with that brief introduction, I'll leave the floor to José Antonio Rivas, who will be the moderator for the program. José Antonio, the floor is yours.
Thank you very much, Rafael, and welcome to everyone to this exciting program on artificial intelligence and the changing face of international arbitration. And before introducing everyone, I think that it's fair that I introduce myself. I'm both an adjunct professor of international treaty arbitration and public international law at Georgetown University Law Center, and I'm also founding partner of Strategy LLP here in Washington, D.C., in Colombia and Panama, and we do international arbitration, and that's the two hats that I'm wearing now, and I've been trying to put together this program for everyone, for the arbitration community, for students, for lawyers, and for practitioners and arbitrators, etc. And thanks to Preeti, who I will introduce in a moment, we were able to partner with the ICDR, Young and International, and also with GIA's Georgetown International Arbitration Society. Today we have a really remarkable number of panelists. First, Isabel Yishu Yang, who is the founder and CEO of Arbilex. She really is someone that epitomizes the qualities of a power woman in every sense. Isabel founded Arbilex, as I said, and Arbilex is a predictive analytics startup specializing in international arbitration. Since its official launch in August 2019, Arbilex has advised a portfolio of investment arbitration cases worth more than $12 billion. Global Arbitration Review shortlisted Arbilex for the Best Innovation Award in 2020, and currently Arbilex is leveraging its in-house AI and predictive capabilities to launch the world's first quantitative litigation fund. Isabel holds a JD degree from Harvard Law School and a master's degree in economics from Oxford University. So she really has the legal and the economics under her belt. Now, next is Preeti Bhagnani, who is a partner at White & Case in international arbitration. She acts for companies and states in commercial and investment treaty arbitrations under all major arbitral rules. Her industry experience includes dispute in the oil and gas, power, financial, and pharmaceutical sectors. Before joining White & Case in New York, Preeti worked as in-house counsel for an international energy company based in Singapore. So Preeti is also a remarkable, she's also a power woman, clearly. But what's interesting also is her diverse experience outside of big law firm or before big law firm. She has really the view of the client because she has been a client, and she has the view of providing counsel to companies and states, which is very important here. And I think last but not least, Eric Blinderman, who is CEO of Theorem Capital Management, which is a third-party funder, and Eric launched Theorem's US operations in 2016 and has overseen its growth and development. And saying that they launched Theorem in 2016 in the US is no small thing, because as many of you may know, some of the funders in international arbitration and litigation come and go. So the fact that Theorem is strong and has developed its roots in the global market and in the US is a lot to say, and speaks a lot of Eric's achievements in Theorem and in litigation funding. Before joining Theorem, Eric was international litigation counsel at Proscar, and served as an associate general counsel of the Coalition Provisional Authority and as chief legal counsel and associate deputy to the Regime Crimes Liaison's office in Baghdad, Iraq. So that only shows how experienced Eric is, the breadth of his experience globally as an attorney, in peace processes, and not only in litigation funding, because he really knows more than funding and a lot about geopolitics from what you can see. Anyway, with that, I would only end by saying again thanks to our co-organizers, to Rafael, to Luis Martinez, who is connected with us, and to GS and those involved, including Ashta from GS. Now, let's jump right into business. There's a lot about predictive analytics and AI, artificial intelligence, that we have heard, and the world seems to be newer every day, certainly with the pandemic, but even before the pandemic, we all know that artificial intelligence is a question mark for most of us. How can it be used? How does it work? And for those of us that are in international law and international arbitration, part of the questions are: could it be used? Could it be used for predicting the outcome of international arbitration, commercial cases, of investment arbitration cases, etc.? How can it be used? Would it be ethical to use it? Some countries have taken a very limiting approach, almost banning it. But those are the questions that we will be addressing. And the first question is really to Isabel, so that she shares with us how could it work. And when I ask this question, I caveat that our audience is not necessarily hyper tech savvy. We may have many that are, but most of this I would suspect that are not necessarily tech savvy. So how does it work? And if you could explain that for our public in general terms, and I'll follow up with additional questions. So take it away, Isabel.
Well, thank you, Jose Antonio. Can you hear me okay?
We can hear you okay.
Awesome. First of all, thank you so much for putting this together and for that glowing introduction. I just want to say the collective brain power of this panel putting together way exceeds my pay grade and my years of experience. So I think what would be most helpful from my perspective is just, like you said, kind of prime the introduction with a bit of a framework to help this discussion. So one thing I would start off is always just to give a general definition of what we mean by artificial intelligence. Artificial intelligence, what we're really describing is a family of computational algorithms that are capable of automated to semi-automated statistical learning based on training data set. So that's kind of a common feature of artificial intelligence, but really if you break it down by the use case that we have seen in law and international arbitration, really there are two families of artificial intelligence or statistical machine learning methods. First is in the family of what we call deep learning models. The other family is traditionally what we call classical machine learning models. And so in the deep learning models, we have a lot of methods that are already being made popular in the press, such as natural language processing or question and answering systems. And the most sort of universal use cases of deep learning algorithms as far as law is concerned are in e-discovery or in technology-assisted reviews or in just making like better search engines for international law. And we have seen a lot of great legal texts, both in law in general as well as in international arbitration, kind of really taking advantage of deep learning and natural language processing power to make the experience of counsel a little bit more seamless and efficient. So that's one family of artificial intelligence. The other family is what we call classical machine learning models, and these have its origin in statistical learning, such as what we do at Arbitration. We focus a lot on a family of classical machine learning powered by statistics methods using Bayesian analytics, and that's a family of models that deal a lot with questions of probabilities and predictions. So both families of artificial intelligence, deep learning, classical machine learning, have two things that I think it's important for audience to understand. That these are two sort of similarities or both sort of observations that we need to take into account when we are orienting this discussion. The first thing is, no doubt, as data increases, the model performance improves, regardless of what artificial intelligence model we're talking about, right? So data is the fuel of the engine of artificial intelligence. That is just true of all families of statistical learning. So that's, I think it's already obvious to the audience. The second point that I want to make, and kind of how we think about artificial intelligence in international arbitration, is this trade-off, the inevitable trade-off between computational efficiency and interpretability. What that really means is, regardless of what AI model that you choose to use and to solve what type of problem, it inevitably involves a balancing test between how much decision you want to be left for the data to address in an automated fashion, and how much human intervention, how much domain knowledge you want to bring to the model. So on the one side, we call it a computational efficiency. The focus is really on automation and efficiency, right? How can we make the quickest decision, parse through a huge body of data and come up with some pattern that can help us make decision. But on the other end of the spectrum, we're really focusing on reasoning. We're focusing on the quality of the decision. And it inevitably would involve a lot more involvement of domain expertise and experts. So I think nowadays, as you alluded to, many different governments have taken their different approach to regulating AI and regulating algorithm. What they're truly regulating, I think, is this balance between computational efficiency and interpretability. And increasingly, we see the regulations coming out of EU is focusing more on interpretability, right? Because as the decisions we're leaving to AI to make become higher and higher stake, we actually need to demand a little bit more about the underlying model, because a lot of the data without human intervention has its innate biases, and if we don't address that from a modeling perspective from the outset, it does create a lot of unintended consequences. And then in the US, we're already seeing over sentencing of certain minority group using automated sentencing algorithm without fully understanding the intrinsic biases in a data set. So at Arbitration, what we're really trying to do is, we understand that in international arbitration, especially in advising counsel in these really high stakes arbitration cases, the decisions are really, really high stakes. So because the decisions are very high stakes, we err on the side of demanding a lot more interpretability than most AI companies out there. And I think that's due to two necessities. One is when you make a lot of high stakes decisions, by design, there are fewer of these data points, right? If you think about how often do we observe, a multi-billion-dollar decisions rendered by a tribunal versus the frequency of observing someone clicking on an ad on Facebook, right? Just by design, the former category have a lot less, repeat in history. It's just the design of the problem is such that basically means even if we have the entirety of international arbitration cases at our disposal, like just not even talking about confidentiality yet, even if we were to have the entirety of international arbitration caseload at our disposal, we're still dealing with a pretty limited data set in the grand scheme of things when we talk about artificial intelligence. So inevitably, this is an area that we need to demand a lot more interpretability and have a little bit more statistical grounding when we use AI. And the second reason for this almost overemphasis on interpretability is because the consequence of getting it wrong, it's pretty bad. So this is not saying like Netflix recommends the wrong movie, okay, that ruined your Friday night, right? This is about advising the wrong tribunal member that does not see the case through your lens, and that could have hundreds of millions, if not billions of dollars of economic consequences, not to mention if there are economic injury or other injury that's ongoing, then that's, so I just want to contextualize this discussion by saying that's how we think about artificial intelligence at Arbitration, and I'm happy to take this discussion any way you want.
Well, let me ask you a couple of follow-up questions.
Sure.
The first one, and thank you for making so clear the tension between what you call computational efficiency on the one hand, and on the other hand, interpretability. Now, in that tension, I understand that there is a question mark as to the largeness or the volume of the data that you have in international arbitration, as opposed to the volume of the data that you may have in other fields. And one question which may be very useful to address is whether you have found that there's sufficient data in both international commercial cases or arbitration and international investment arbitration, because the volume of the universe from which you can learn may be limited, and some of the questions that we may have heard are, is there sufficient data to predict anything? Can you do it? Can you not do it? So share with us any of that and your experience, which I'm sure everyone is eager to hear from.
Yeah, absolutely. I think you hit the nail on the head. That was the riskiest assumption when I started Arbitration, which was also why when I started Arbitration, I was holding a full-time job offer from Sherman Sterling. So I'm like, if the statistical model doesn't work, I'll go back to big law. So I can say that from my vantage point, I'm a little bit biased in answering that question because my training is in development economics. Development economics is a subfield of economics where the focus of statistician is how do we tailor a lot of the advanced statistical methods developed in the advanced economy where you have perfect data set, how do you adapt that type of method for developing country context. So even before law school, I spent 2 years, and Jose Antonio also have like extensive treaty negotiation experience. I spent 2 years advising South African treaty negotiators on how do they model the different scenarios under sort of tariff line negotiation and trade and investment treaty negotiation context. So over there, the type of quality and data that we're dealing with is a lot more limited than what we're talking about here in the investor state context. So that was one thing that kind of gave me a little bit inkling of confidence that maybe, yes, the data set here is small, but it's not so small that we can't say anything meaningful about it. That was my first inkling of confidence, or that drive my hypothesis. The other inkling of confidence I get is if you think about law and advocacy in general, it dates back to like Oliver Wendell Holmes, right? The idea of evidentiary burdens and how do you argue a case, the flow of each of the case is so structured that I think it's, for me, the first time I read a case, I remember the first time I read a tort case, the language just jumped at me, right? Abundant, like the preponderance of evidence, right? On balance, more likely than not, beyond all reasonable doubt. Those are all empirical descriptions. Right? Every time I read these words, I'm like, I wonder if there is a preponderance of evidence one way or another. So I think what lawyers sometimes actually don't realize is the way that we are trained to think as advocates, it's already very primed for statistical modeling because it's very structured. The evidentiary burden has an inherent empirical angle to it. So taking these two into account, my hypothesis is we can probably get away with a pretty small data set and be able to say something meaningful about it. But at the time, it was a hypothesis. So the only way to really test it out is run it on a live case, right? So what we did back in summer last year, and I consider myself like super lucky, is like the first case we ever modeled. We looked at the tribunal configuration, we looked at the high level metrics of that investor state case, and we predicted, hey, we think that this tribunal would accept jurisdiction with a 53% chance. But we know, as all the seasoned practitioner here knows, the average in an investor state context of a tribunal accepting jurisdiction is 73 to 75%. Right? So for a case where we predict there's a 53% chance of advancing on jurisdictional ground, our prediction is actually more likely than not, there's preponderance of evidence towards this case being thrown out at jurisdiction ground. And so the lucky part for us was actually around the same time, the tribunal came back and threw the case out on jurisdictional ground and slapped the claimant with an adverse cost award. So overall, very sort of pro-respondent tribunal. Now, the caveat of all of this is not to say that, hey, listen to us, we were right, but more so is actually, if you really think about it, this algorithm that we developed, I've never seen an investor state case until the day that we started training it, right? So how quickly, right, this model can pick up a lot of the instincts that counsel took years to develop, right? So what was really interesting is when we show that demo report to a lot of the practitioners, some very seasoned partner look at the tribunal and say, oh, that's very pro-respondent. Senior partners know that. Junior associates, they don't, right? Because these are instincts that take years to develop. But what's interesting is now if you have the aid of statistical learning and machine learning model, is a lot of these instincts can quickly be put to test. And for the junior members, that they can quickly learn these patterns without having to go through like decades of appearing before tribunals and go to conferences and socializing. So a lot of the slope of the improvement is really what excites me here. And I think I never submit that we are going to be the ones of raw solution, but I do think that with the assistance of machine learning and data, the entire team can be supercharged from the junior associate level to like building up these instincts to the senior partner level to like actually testing out their instincts that they have developed for years. So that's actually my long-winded answer to your question is like, is it sufficient to say with 100% certainty? No, never. Like, I don't think any model is. But is it sufficient to be a meaningful addition to making these stressful predictive questions, decisions? Absolutely.
Thank you. I mean, this is fascinating. I would like to welcome Preeti's remarks on what you have shared, and also ask her a question, which is, have big law firm have you as partner began using predictive analytics and AI in some meaningful way, and if yes, how? If not, do you see yourself reaching out and trying to inform yourself better and your colleagues and associates and clients with AI?
Hi, thanks, Jose Antonio. Can you hear me okay?
Yes, we can hear you very well.
Great, thank you. So that was a very interesting. I think the honest answer is I don't think we use AI as often as the potential that the technology has. And I think if you look at the statistics, the most recent survey, I think it was 2018, the Queen Mary White and Case survey asked practitioners and arbitrators and participants in the arbitral process how frequently they use AI for data analytics and technology-assisted document review. And I think the response was 5% of respondents said frequently, and only 3% always use it. So it's not used that often yet. My own experience is, I think, similar. Technology-assisted document review, for example, the tools exist, right? You can train the tool by, instead of reviewing thousands and thousands of documents as junior associates used to do, they could review a sample, determine what is responsive and what's not, and then the machine learns from your responses to determine whether the broader data set, what's responsive and what's not. But in my 10 years of doing arbitration, I've never had a case management conference, for example, where parties said, we intend to use technology-assisted review for document production and try to get guidance from the tribunal on whether or not that would be fine. Now, one possibility may be that people are not using it, or the other is people are using it but don't feel the need to bring it up and get guidance on it. And I think both possibilities, are fair game. There's no rule that says, the IBA guidelines, for example, which governs many sort of arbitrations or uses guidelines in document production, that says you can't use artificial intelligence-driven tools to identify and determine responsive documents and to meet your production obligations. But then on the other hand, of course, there's always that risk that if counsel is delegating essentially to a machine the task of determining what is and isn't responsive, if there is a mistake, then sort of who's responsible, and could that become a basis upon which an award is subsequently challenged? So I'm not sure what the answer to that is, but in terms of what we are, what lawyers are now using, in my experience, we are certainly using AI-driven tools for legal research. So instead of doing sort of more what we used to do, which was keyword searches, which are really not, it's a blunt instrument. Now you have tools that have the sophistication of being able to give you an answer to a question, like what is the standard for a particular obligation in a particular jurisdiction. And there's some tools that offer automated legal drafting. So if you have multiple submissions to be made in parallel proceedings and they all relate to the same set of issues, you might be able to leverage that to avoid having to do, you use one model and that helps you to generate multiple drafts for different audiences. So there are those tools, but in terms of, and of course there's tools that help you to proofread legal documents and avoid inconsistencies by pointing out inconsistencies, and I think corporate lawyers are starting to use that more often. But in terms of arbitration-specific tools, the one that comes to mind is I think Arbitrator Intelligence, which of course aggregates data from different arbitrations and allows you a little bit like a database, but with some AI enhancements so that the report that you get from that relates to a particular arbitrator might contain additional information, like what is the response, the claimant's recovery, for example, in prior cases. And I think that we're starting to see counsel use that more. I have to say that I agree with Isabel's comment. Sophisticated counsel, counsel that are in big law firms, they know the space very well, they know the arbitrators. There is a bit of a resistance, I think, to using these tools, because there is a sense that we know the arbitrators. I have a case, I have a sense of who might be a good fit for this particular case. And so I think we may find that as we have more new entrants into the field, and there are more people who have less experience and less familiarity, but also as counsel are thinking outside the box and trying to propose potentially diverse tribunal members, and tribunal members that they don't have direct experience with, their colleagues don't have experience with, that they may start to use the arbitrator selection tools more frequently.
Thank you very much, Preeti. There's one question that I'd like to ask you in terms of there are no limitations in international arbitration for parties to use AI in general terms, but as counsel, and I would like to ask myself that question, as counsel, would you like to know whether opposing counsel is using AI? I mean, is that something that you think that you should learn if they are using it, or you would simply, because it's very easy to go around the bushes when one is talking about his or her own experience as counsel. Should I be able to use it? And intuitively the answer might be, of course I should, because it's a new tool. But then the real question is, how would you jump or not if opposing counsel is using it? Would you have any issue with that?
It's a good question. I think that I would want to know, the software tells you what is it has statistics that you can see how accurate it is, right? There will always be a risk of inaccuracy, but if it's something like 30% versus 70%, that's a huge difference, right? And so I think that if you were going to, and I'd like to think that if I was going to do this, and rely entirely on an AI-driven software for doc review without manual review, then that's something that I think it would be prudent to agree with opposing counsel, up front. And you may not know at the beginning of the case whether that's necessary or not. You don't often have a sense of the scope and volume of documents until you've seen the document request, you've collected documents from the client, you've run some searches based on keywords to determine what the potential scope of, volume is that might be responsive. And then, so that's further down the line. And often what I think is a practical challenge is you've got like 2 weeks to turn around responses, and then the reference schedule is done. You have a few weeks to turn around on document review and produce, and then you're working on a brief. And so you don't necessarily always have the time or you don't necessarily want to engage in a long debate with opposing counsel at that point about whether this should be done. So some thinking up front needs to be made, and I think some time in the schedule should be, if you think that this might be an issue, I think it's good to flag it up front as a potential discussion item at, maybe even the first procedural conference. Think about building in some time to have that discussion, and then have that discussion before you actually do the doc review, because you want to make sure to leverage the efficiencies of the model, then you don't start down that process until there is a framework in place that's been agreed.
I mean, that brings up a fascinating point, which I hadn't thought of, which is one being, of course, very transparent about the use of artificial intelligence, and particularly artificial intelligence for the doc review, and that even brings up the issue of perhaps you want to bring it up right at the beginning at the procedural conference, to even plan that it could be used not only by one party but by both parties, and that might even take it as far as the tribunal could even consider it a useful tool for the fairness of the process, and that of course brings me back for just a short while to Isabel in terms of using AI, for instance, for doc review. Is that something costly? Would that be something overly burdensome for the parties? Because at the end of the day, parties will be thinking about cost.
I think doc review is a more mature use case of AI and now has been more commoditized. So I would anticipate of all the other AI technologies out there, this might actually be the most cost efficient. But hey, you should ask Eric. Eric's the one who review counsel's budget all the time. So maybe he has a more bird's eye view on this problem.
Yeah, well, let me ask one question, one similar question. I have a number of questions, follow-up questions, but perhaps the most important part here is who could use AI in international commercial arbitration, in international investment arbitration, and of course it would be very useful for all of us and all the listeners and viewers to what extent funders are considering using or are using AI and predictive analytics to make their funding decisions. So Eric, the floor is yours.
Sure, and thank you again to everyone, to Rafael, to Isabel, to Preeti, from everyone from the ICDR for organizing this event and for taking the time to put together all of the panelists and this assembly of knowledge. One just sort of quick caveat, I'm the CEO of Ethereum's US operations. I appreciate the promotion at the outset, one day soon. But I think as a 30-second overview, it may be helpful to describe sort of the differences between what a third-party funder does and sort of the general practitioner's viewpoint on a day-to-day basis. And having worn both hats, there's a tremendous amount of overlap between what it is that Preeti is talking about and Isabel is talking about and what we do at Ethereum. And in that vein, what Ethereum does is provides capital to claimants traditionally, although it's not completely outside the realm of possibility that we could be funding a potential respondent, assuming it's the funding is included as part of a portfolio with a liquidity event. But generally speaking, we're providing money to claimants who lack the capital to prosecute an otherwise meritorious claim. And in the arbitral context, Ethereum is funding everything from investor-state arbitrations to international commercial arbitrations in a variety of arbitral fora all across the world. We have over $1 billion in AUM, and our portfolio is, I teach international commercial arbitration at Vanderbilt, so I sort of invest in what I know coming from a value investing perspective, which means our portfolio, I think, is, I don't want to say it's skewed towards arbitration, but there are certain efficiencies that one sees with respect to just the decisional capacity of how arbitral decisions are made in comparison to domestic litigation, and which also lend itself more properly to the application of AI and machine learning and the tools that Isabel is talking about. And on that point, I think it's really interesting to point out on one of the comments we have in the Zoom group chat, which someone wrote, big data is unstructured, most of it, who will process the data and present it in a comprehensible, usable form to an end user. And that's where tools like Arbilex come into play. So in a perfect world, when one is talking about the application of AI and machine learning, you're looking at the holy grail of, I have a set of facts and a bounded area of law, and can I come up with an outcome of some type of confidence ratio that the likelihood of success on the merits is X and Y, and look, in a perfect world, in 100 years from now, litigants will walk up to some computer terminal, type in their, individual positions, and it'll spit out a decision. We're clearly not there yet, but that holy grail is the critically important component of what Ethereum is looking for as a tool for us to utilize. And the reason for that is we're using human-based experience to come up with, a magical divination of how we perceive an outcome will arise based upon all of that experience that people were talking about, right? a big lawyer has a tremendous wealth of knowledge, who's practiced for 20 years about how a particular arbitrator is going to decide a matter. And that's because that particular big law practitioner has worked with that arbitrator before. They know what that arbitrator is going to ultimately be predisposed towards deciding on. And if you don't have access to that wealth of knowledge, absent the application of big data, then you're going to be at a handicap. And so some of the tools that we're talking about and the resistance to the application of those tools are, sort of the usual cabal of, the sort of guild system and people protecting their interests. So in a perfect world, what one would expect and hope is that you can utilize these tools to facilitate the rapid resolution of a decision. From a practical perspective, Ethereum has a strategic relationship with an AI and machine learning data amalgamator and provider and algorithmic-based learning tools that we actually utilize when underwriting a case. The problem with that is, from an empirical perspective, at least on the domestic litigation side, because there's such an enormous amount of data, we can have an identical set of fact patterns in really even the same courts, and they can be the same case, just sort of filed slightly different because they're companion cases, and we'll see a confidence ratio of 98% spit out on literally like the exact same case, and then a slight tweak in, the name of the claimant or just the most basic thing, and all of a sudden that 98% confidence ratio drops to 40%. And so all of a sudden your reliance upon this data has to be somewhat circumspect. And so you're reaching a point where you're trying to rely upon this information to make reasoned decisions, at least from the Holy Grail perspective, and the human element still remains. On the application of big data and machine learning to discovery and predictive coding and sort of all the elements that you want to utilize to ensure that, frankly, lawyers are working within their budgets, I do think, as Isabel pointed out and Preeti mentions as well, the use case for that is very well developed. When I was a practitioner, we were utilizing that type of material just ad nauseum as part of our practice. The days of 50 associates pouring through documents, I think, are over in large part because clients don't want to pay those bills anymore. And I think, generally speaking, the results you might get from a algorithmic tool are probably more consistent, even though there is a risk for error that Preeti identifies and that tribunals are necessarily struggling with. And look, I've seen fights over the elements of how you're going to define the algorithm, and even before you're dealing with discovery, about how to your keywords and your search terms and the elements that are going to be fed in. So all of this comes into play, but at its core, from a budgetary perspective, I want to see that discipline imposed. I want to see lawyers utilizing tools to become more efficient. It gives me confidence as we underwrite that the lawyers are going to stick within budget, that they're going to be more effective in deriving an outcome, because at its core, from an underwriting perspective and from what a litigation funder is seeking to accomplish, we want to put money out on behalf of our clients. We want to put out as limited amount of capital as possible to get a return that is commensurate with what our investors demand, but ultimately, which will be more than enough to allow the individual claimant to accomplish their financial goals in having instituted the litigation or arbitration at the outset. So that's my long-winded answer. I'm going to pause at that for people to
Thank you. Thank you so much, Eric. I mean, that really gives us a view on many issues, including how a funder and perhaps other funders are looking into using and utilizing artificial intelligence and predictive analytics, but also on the issue of cost, which is often one that is in the mind of all users of the system of international arbitration, and because we have had the perspective of counsel and also predictive analytics innovator and also a funder, I think it's only fair to see the perspective from another view, which is the perspective of the state. You know, I take now my hat of former and current counsel to some states that see all these developments and are very much aware of these developments. And the issue here is, you know, can they use it? Can a state use predictive analytics? Can they rely on it? Would it be useful? Would it be more expensive? Will it be more? Will it be more cost effective? Just to address that issue, the sense that I have is that in many respects, as Preeti was signaling it, for instance, for document production, that's an area where I see everyone benefiting, both counsel for the investor and counsel for the state, using artificial intelligence for the whole review of documents, to take it to another level. It could be an area where costs can be reduced. My take on it is that you would need to define very early in the game the parameters, so that things can be efficient, and not define them midway, because that could be even more costly. But from the beginning, that could be more efficient for everyone. And then the next issue becomes, can they use it in any other fashion? And my general sense is that at an early stage, states can very much, or could very much, rely on predictive analytics for things that are normally done by the law firms, including the arbitrator selection. That is an area where perhaps, and I would welcome Isabel to correct me if I'm wrong, but that is an area where perhaps there has been the greatest development in predictive analytics in international arbitration. Basically, how the case looks like if X, Y, or Z were appointed, or how the case would look like if Y and Z were selected because X has already been appointed, right? So that's an area that really could be used by states. I mean, I as a former counsel and an associate in big law firm, that's an exercise that you're always doing. You're always looking into the cases that the various potential arbitrators have done, the outcome, how have they been influenced by other arbitrators, how have they influenced other arbitrators, what is their background, what have they written, whether they come from public international law, whether they come from international commercial and corporate world, etc. Those areas are ones that I believe can ultimately be included in the parameters that those that define the algorithms do, and the outcomes are already there. So that's sort of my take. And now taking it to another level, what I would say is then beyond the influence that the choice of the arbitrators could have on the case, which I see a clear way to program this. What other variables can be taken into account? I mean, that is, to me, one of the hardest questions. Can you take other variables into account? But before jumping into that, I would like to welcome your remarks, Preeti and Isabel and Eric, in terms of how the states can use predictive analytics in international arbitration.
I might just start, and then everyone feel free to jump in. I think, thanks for bringing up the state perspectives, because that's something that, as a former sort of policy wonk, this is something that's very close to my heart. I think all of this discussion lands is justice has a cost, right? Justice is very expensive, in particular from a state's perspective. We see that, really play out, right? States sometimes, especially the ones that have been sued repeatedly, are trying to accomplish a lot with very, very little resources. So other than the existing use case that we already developed in tribunal selection, where we try to help states is, how do you mitigate risk and uncertainty from the outset, given you have a limited budget? And some of the the proposal I put forward to states. Some are more controversial and some are, you know, they're more receptive. Let me start with the most controversial, and then I welcome other people's perspective. I believe that from a state's perspective, especially when you have, you know, repeat claims generated from similar fact pattern, it's actually from the state's interest to look at these cases as a portfolio rather than a single case after a single case after a single case. Right? And very few states out there are fit that description, but for the ones that do, and I think Jose Antonio, you know which ones I'm talking about, I think it's worth actually investigating from the outset that what is the state's sort of collective response in mitigating the uncertainties across this portfolio of cases. And this is the type of analysis that I think data analytics companies do best because of the extensive nature and the comprehensiveness of that inquiry. Obviously, once we have a first cut answer to those questions, like what we believe, oh, within this portfolio, generally we think that this is the duration of these cases, this is the likely payout, these are the stronger case, these are the weaker case, then collectively a state can decide, do I want to settle, you know, with these folks so that I curtail the duration risk, or do I want to fight these stronger cases because I think we have a stronger chance of success. But I do implore states and, you know, counsel for states that are dealing with repeat claims and in a sort of portfolio fashion to really think about these uncertainties in a more systematic manner. And that's something that we're really ready, willing, and happy to help with. So I'll pause there and then see if other folks have.
Yes, go ahead. And before simply turning the mic to Preeti and Eric, I would just say that within the next 8 minutes, we'll address this question, but then for the last 15 minutes, I would like to turn back to some of the questions that are really, really, really interesting and try to address them. And also, I would encourage all the participants, if you have questions, please share them with us in the chat, and in that manner we can try to address everyone's questions within the next 20-25 minutes or so. So let's address this question that we had for Isabel, Preeti and Eric, and happy to hear your comments.
Yeah, I would just say I echo Isabel's view, and in cases where we have been appointed by a state and there are multiple 5, 6, 7 arbitrations against the same state, we've worked very closely with the state to make sure that they are being considered as a whole and they are being thought of, strategically managed in a way that reflects the state's best interest. It's not always possible, as some cases, the states that are being sued don't necessarily have the capacity to undertake the type of management on their own of a portfolio of cases the way that Isabel is envisioning. And, in other cases where there are multiple law firms acting for the same state in multiple cases, there needs to be sort of earlier coordination by someone, on the state side between the different law firms. And that makes it much harder, I think, to provide that sort of seamless strategic thinking and looking at the whole set of cases as a portfolio, not just the cases that are here today, but also the cases that are in the pipeline that are going to come because of whatever measure the state enacted, right? And it's so important because every submission that the state makes can be used against the state in a subsequent case, and public statements, interpretive, joint interpretive declarations, and so on. So there is, I definitely echo what Isabel's thinking is about being proactive in managing this. I don't think, I personally don't have experience with using AI tools in doing that, but definitely we'll look out for that opportunity next time.
Thank you, Preeti. Eric?
Yeah, I was just going to echo everything that Preeti and Isabel said with just one caveat. There was a time in a former life where I was serving at the principal level of the US government and was interacting with sovereigns and making these decisions with exposure. And I think it's important because, as Isabel correctly identifies, there's a common nexus between a variety of different type of claims, which a rational actor who is focused strictly on an economic outcome should analyze and understand. The problem with that is that sovereigns are oftentimes making these decisions not on an economic basis, but for political reasons that are designed to effectuate specific policy goals. So to the extent that the portfolio analysis can inform the policy and political goals, I think that is a tremendous value add. But one needs to keep in mind that states are acting in a variety of different interests that are very different from commercial actors, and that impacts the application of how these tools will be most effective to decision makers.
Thank you, Eric. And that, you know, that is such a useful way to understand, because the tools may be there, but it's that dilemma which some states may have concerning dealing with maintaining a certain measure, or even deciding to negotiate or not a settlement. And sometimes the logic of it is simply different. The logic of some state, for good reason, may be it may be better to get an adverse award than modify the actual measure that is being claimed to be in breach of international law. And sometimes it is a matter of public policy, health or otherwise, which brings me to we have just 3, 4, 5 minutes before we go through each one of the questions that haven't been responded, and both Isabel and Preeti have introduced the notion of a case or a portfolio of cases from the side of the state, and that really rings a bell in terms of certain critical moments in investment arbitration at different times in history. So you have the Argentine crisis at the beginning of the century. You then you move forward and you may have all the measures in Europe or in Spain concerning the new environmental technologies that are now being seen by tribunals. And if we fast forward, we can look into potential cases related to the measures that states may be now taking, both for public health reasons related to the COVID and also for economic reasons to provide relief to domestic investors. So you can actually think that there could be a surge of cases 1 year from now, or 1.5 years or 2 years from now, related to all the pandemic. So the question here, and I admit that when preparing this panel, we discussed among ourselves the question, and we might not be able to provide the answers, but to me it's a fascinating question as to whether predictive analytics could have something to say, or could have something to provide for the perhaps new wave of cases that may come as a result of the pandemic and the measures, economic and public health related measures that we may be seeing. So that's a fascinating question. I'm not sure that we can predict the answer, but let's see.
Do you want me to answer first?
I think you might be a panelist here, so yes.
The way I see this question is somewhat akin to predicting how the stock market will behave given a certain election outcome, for example, right? So we know that a certain election will have a systematic impact on stock market, but we have never exactly seen this particular election before. But then we have seen similar types of elections, right? So just to give you an example of folks that works in fintech, when they were trying to predict how the stock market is going to behave in the event of President Trump being elected, the sort of training data set, right, or the sort of like events that they feed into the algorithm are historically like protectionist, or you get what I'm trying to say. There's a special genre of candidates that are kind of like President Trump. And so in order to model what that likely outcome will look like, we look for historical sort of political events that kind of look like that. So I think the effectiveness of using AI or technology to help mitigate the risk arising from, you know, COVID-related cases is really dependent on experienced counsel like everyone here on this panel, your ability to define likeness between these future events and what we have observed historically, right? If you believe that the COVID enacted measures are very much similar to certain type of, let's say, environmental measures enacted for protection of public health, how those cases have come out by what tribunal, if you think that those are like the COVID cases, then as technologists and statisticians, what we would do is increase the weight, right, of training data set for those type of cases that you believe are similar. So a lot of it, again, going back to my first comment here is the trade-off between computational efficiency and interpretability. And at the core of interpretability is, what do we tell the model as our sort of baseline assumption? What do we tell the model as the ground truth that we benchmark our performance to, right? So historically, if we, and ultimately, the test is always going to be in the future, right? Anything that has anything to do with prediction, you're not going to be able to find out the right answer right now. That's what's fascinating about it, right? You can say, you can put up your best guess, but you're only going to find out if you're right or not in the future. So what is the best process to come up with that best guess? And usually as a statistician, and I think as lawyers similarly, is we try to dig into history for things that have happened. What do we think from history that most resemble the fact patterns and the and other metrics or variables in your words of what is about to happen, right? So the more we can draw that analogy, the better for pattern spotting and the more accurate we're likely to be. But again, any of these things are sort of just not taken into account, like black swan events. I mean, you can still have, you know, things that are just completely out of the realm of statistical predictions. But in order to get to best guess, I think that's the exercise we would do.
Excellent and great. I mean, I think that in order to sort of make it very, very close to the type of cases that you would look to basically build your model, you might agree that you might have to take into account, say, for instance, what are the past cases, both in public international law and investor-state arbitration, that have dealt, for instance, with state of necessity, with force majeure, etc., and take it from there to construct the basis and then predict what could be the outcome. But beyond that, let's see what your respective takes of that may be, Eric and Preeti, in whichever order you want.
I guess I will say that, so I am not a tech person, but my impression from reading the literature is that we are still far, and Isabel may correct me if I'm wrong, but we are still far away from a world in which we can get accurate predictions to cases. And I think Eric touched on this when he mentioned that example of you tweak a tiny parameter and the confidence level drops from 98 way down. So for example, I think the big study that I can think of is the study of Supreme Court decisions in the last 2 centuries worth of decisions, I think, is what they took. And it arrived at a pretty impressive, the model was able to predict, I think overall with 70% confidence, how the decisions would come out. But, and Maxi Scherer has a great article where she analyzes the limitations of that study, and she identifies some pretty significant limitations. One being that all of these cases are where the Supreme Court is either just affirming or overturning a lower court decision. So it's not acting, you know, the model wasn't yet intended to predict the outcome of a case where the Supreme Court would be deciding a case originally in its original jurisdiction. And so that's a pretty big limitation. The other is, of course, I think Supreme Court decisions are somewhat different in the sense from most decisions in arbitration, in the sense that they're often very politically dependent, and justices have very different voting patterns depending on their political affiliations. And so it's not clear to me to what extent we will see that level of accuracy when we come to investment arbitration, and then probably even less so when we come to commercial arbitration decisions. The only other study, a big study that I know of on how outcome predictions is the European Court of Human Rights decisions on whether or not there was a violation of the convention. And again, I think in that one, they used the decision itself, so parts of the decision that deal with the facts as the inputs. And then you can fairly ask the question, well, what does that tell you really about whether you can model in advance the outcome of a decision? Because often the way a decision is drafted, even though it might be describing the facts or the procedural background, is already influenced by the outcome. So it's not clear to me where we are exactly on how well we can actually predict outcomes of decisions.
Thanks, Preeti. Eric, have words to share on that?
Sure. I think I agree with everyone, which means there's no clear answer. Even at Ethereum, we are seeing a lot of commonalities in a sort of COVID-altered world in terms of the types of claims that we're seeing that would arguably lend itself to the application of AI and machine learning, and whether it's an investor state or commercial arbitration or domestic litigation. You were talking earlier, whether it's a force majeure clause, the language of those clauses, they're fairly uniform. I mean, there are distinctions, but as you sort of look at those clauses, or whether it's a material adverse change clause, or common law, at least notions of impossibility or frustration of performance, you're going to see a lot of, and we are, types of claims that share a common nexus of fact as well as application of law. And in those bounded circumstances, I think you are better able to apply machine learning and AI, subject though to the caveats that we've talked about earlier. I'll just give you another example. I gave you the 98-40%, but just recently a company called NVIDIA, they taught their algorithm how to play Pac-Man by watching Pac-Man. So literally it was like 50,000 applications of this computer-based machine learning algorithmic learning facility to watch Pac-Man and then recreate the entire game of Pac-Man. No one typed in a single bit of code. It just literally recreated Pac-Man from scratch, and you can play it. The problem with that is, even in such a bounded set of rules in less nuanced world of you eat the dots and then you go and kill the ghost, the NVIDIA final application, still they had to teach, the concept of how when a ghost, got to Pac-Man, Pac-Man needed to die. And even then, it was still sort of fuzzy when it sort of recreated, the application of the game to the real world. And that's really just another way to, change my anecdote of the 98-40%. We're getting closer, and I think there are COVID-related applications that lend itself. And we utilize it and need to be tracking it and following it. Whether we're quite there yet, I know that's what Isabel's working on.
I mean, one thing that seems very clear is that we're as you rightly pointed out, we're not at a stage where you can just simply get to the machine and write the legal issue and get a paper with a yes or no answer. We're not there, and there needs to be a very strong interaction between the programmers and the actual lawyers or users. But beyond that, there's many questions. Some of them we have been answering throughout the panel. There's a couple of questions that I think we can answer after the actual panel related to existing references to AI tools that may be out there. I'm sure that we can answer that after that. But there's one particular question concerning whether predictive analytics and the use in international arbitration, especially concerning arbitrator data, would likely make the world of arbitrators more or less diverse. Will that impact the push for greater diversity in a negative or positive way? I have my own opinion, which is actually favorable to AI, but I would welcome your perspective, because I think that it's a very interesting question. And I'll read it to you. Yeah, I mean, do you think that such predictive analytics would prevent the appointment of new faces as arbitrators? That's the question.
I'm happy to jump in if
Yes,
nobody
yes,
else is. I think it's uncertain. What people are striving for is predictability. So I've talked about uncertainty in the answer to the question, yet juxtapose that with the notion of certainty. And so implicit in the question is for the predictive analytics to make sense and to be effective in ensuring that an arbitrator who wants to be appointed gets appointed, that they have a track record that shows some consistency so that an outcome that a particular party who's seeking to select an arbitrator is more likely to get. And if people who don't have a track record with that level of predictability, then yeah, all of a sudden your algorithm is not going to spit out your name to somebody, and that could be a real barrier to entry. I don't know how to overcome that. And I think it's a cogent question and something that people need to consider.
Yeah, Preeti?
Yeah, it's interesting, and I think Eric is right. You know, it brings to my mind the Amazon example. I'm a little vague on the details, but I think they had come up with an AI-driven model to help with hiring, and they found that it was biased against women. And I think you look at the data set, and more of the people that seemed to rise up in the ranks in the company were men. And so you teach, that's sort of what the algorithm learns. And so that's what it spits out. So, I think that I suspect that you're going to need to tweak the model earlier on to avoid that sort of bias, right? And to suggest, for example, that, or you might even take gender out of the equation. So that might be one way to mitigate the risk. Instinctively, I would think that it could be done in such a way, could be trained in such a way to actually help with suggesting diverse candidates, even if that means, yes, I completely agree they need to have a track record, but that track record may not be necessarily, in exactly the space. Might be other arbitration matters, not necessarily investment arbitration, but a good commercial arbitrator, with a strong track record might well be recommended for an investment case, for example.
I know, Isabel, and yeah, go ahead.
Can I quickly jump in, just kind of like my big picture answer to questions like these, which have been posed to me time and again, over and over again, is I think the tension that we have been discussing today is there is this difference between the availability of technology, right, what technology can do, and what is the user's perspective at the adoption stage, right? So, and if I can use that framework to look at this question, is diversity is something, it's an objective that we can model. The issue is, does counsel want to model diversity as a higher priority over predictability of granting massive damages in the context of expropriation, right? As a technologist, we're agnostic to what objective our clients want to model. The issue is, at the user level, what is the client's like real list of preferences. So I think diversity is something that, you know, very close to my heart. Like I speak on these panels, the first thing I do is I send these ads to arbitral women, you know, to have them market, and so everybody can pitch in. But I think this is one of those issues that it really, like, technology is quite neutral in this perspective. If you want to model diversity, we can. If an institution, let's say Exit, come to us and they're like, next candidate we propose, it has to be a woman, someone from emerging market, but also like with experience of handling this case. As technologists, the way that we're going to model that is exactly what Eric says. If they don't have a track record investor state, then we go to their writings, right? We go to their other decisions, like when they were judges in their domestic court. Can we do that? Can technologists do? Absolutely. The technology is available. The issue is when we're working with counsel, the people who actually pay us for our services, to them, quantum might be a bigger issue there, or granting provisional measures might be a bigger issue there. And the predictability of doing such things are a bigger issue. And therefore, we actually have to look at, you know, candidates with a more repeat track record. Over time, I think if institutions are more serious in, you know, actually putting more folks and giving track record to more, like a bigger set of arbitrators, and if our clients are telling us, hey, diversity is a much bigger concern than us, to us, than the track record of granting multi-billion-dollar damages in the expropriation case, then the candidates we propose are massively different. So that's just, no, it's not to defend technology, it's just to say that sometimes these sort of policy objectives from a technology perspective is actually neutral. Sometimes it's the user's perspective that drive a lot of these skewed patterns.
Thank you, Isabel. I mean, that really touches on the crux of the matter of what are the variables that you will be starting from. I'd like just to let everyone know that we've passed our time to be here, but very happy to continue for 7 or so minutes to wrap it up. There's a couple of questions more on the prior question. One of the key elements that I found is that everyone is very much, in general terms, in favor of diversity. Everyone is very much in favor of opening up the possibilities. I actually had a specific sovereign state client at some stage who was very much into making a push for greater diversity in the pool of arbitrators. And when the time came to look at the names, the specific area of diversity where the client wanted to open up the pool didn't have that many candidates, and the question was posed. I mean, do you really want to look into something that would allow you to better predict what the outcome might be, or do you want to try new names without that track record? And as much as the client wanted to open up the pool of arbitrators, the client said, listen, my responsibility is actually to the state, and I would rather have something that we would know we might be better off by selecting a particular name or names. So that is a lesson, because of course everyone wants that. But I want to stress that there are barriers to entry that can be overcome, even if there's no track record. There's always, if somebody's being considered, even if they don't have 5 or 10 cases under their arms, there are things that they have done, opinions, decisions in their courts, even the briefs as counsel, writings, and that, of course, as Isabel has stressed, that can be included in their algorithms. Now, a last topic that I would like to put a question on is whether the use itself is ethical. Would it be ethical to use AI in international arbitration, and someone has asked, whether even the consideration of using it would be ethical to the extent that this should be absolutely neutral, or international arbitration should be absolutely neutral if we accept the notion that international arbitration is also the impartment of justice. So what would you say in terms of, yes, it is fair to use AI in international arbitration, or there might be parts where it becomes less fair to do so? And that's a question to any of you.
I guess I'm happy to jump in there. I think the answer is it depends on what you're using it for, right? How are you using it? We talked briefly about doc review. There, I think that, again, if there is clear agreement up front, that would be fine, and potentially even everybody might agree that it's even better because it avoids the risk of human error. If you're talking about an arbitrator using an AI tool to to help with just the kind of work that ordinarily a tribunal secretary might do, so summarizing the submissions, assisting with legal research and things like that, I can't see that there would be an objection to that. When you move beyond that to an arbitrator actually relying on an AI tool to make a decision, that's where you get into, I think, more gray area, right? I don't think we're there yet, but it's certainly something that is potentially on the horizon. Counsel has appointed the tribunal member, clients have appointed the tribunal member to exercise their own judgment, intuition. They have a right to be heard, and I think arguably you don't. You don't get a right to be heard when it is a machine that's making the decision. So I think that's sort of one set of questions. And then I think the other set of issues that arise with the use of AI, it comes from what we had already touched on, which is the potential bias in the way that the algorithm is trained, and how that could lead to systemic errors in whatever decision is being recommended. And again, that, I think legislators are looking at this. In the US, they recently, I don't think that they've passed it yet, but there was a proposal I think it's called the Algorithm Accountability Act, which, if passed, would require the FTC to require anyone that holds repositories of information about personal information to conduct an impact assessment to see if automated decisions, what sort of automated decisions are being made based on that information. And the goal is to make sure that biased decisions are not being made based on data.
Thank you. Any word before we close off? Isabel, Eric?
I'll jump in and then Eric can wrap up. I just want to say, going back to my perspective from the outset, this trade-off between computational efficiency and interpretability, whatever AI, whatever use case, whether it's law or something else, that trade-off always exists. I think the more counsel and users become sophisticated, like Eric, for example, here is a perfect example of that. The more sophisticated we become about what is it that we're talking about, and the more emphasis being placed on interpretability, I think the more likely we'll be in a place where it's fair and ethical for everybody. What I'm seeing now is there are sort of a lot of criticism being thrown at AI as far as law is concerned, has a lot to do with just resistance to change and fear of change. And I think that's unnecessary. I think once that we engage in a more open dialogue about what is it that machine actually does, what we will realize is never a question of machine versus human. Even in the perfect world that Eric outlined, that the machine can crunch out probability, that machine is a collection of brain power from counsel and users in the system. It's never really this abstract artifact of, you know, some like crazy robot sitting in a corner trying to like kill humanity. It's always a dialogue and an iteration, a lot of blood, sweat, and tears of programmers, lawyers, you know, interdisciplinaries, people like me, that trying to come up with tools that make the system a little bit more efficient. Because at the end of the day, questions about technology are questions of access to justice, right? If we make the system so deeply, you know, inaccessible by, you know, folks with budget concerns, then there's injustice and lack of ethics in that system as well, right? So I think really the question about AI and ethics has to be contextualized in a bigger context of what do we think are the right balance between computational efficiency and interpretability, and how does that link to important questions like Preeti mentioned, like due process? How does that link to questions of access to justice from a cost perspective, from you know, state perspective and claimant perspective? And so I think we're at a place where these questions are now being posed forward, and I think that's great. And you know, panels like these are you know, opportunities for all of us to get on the same page and really understand that these are very difficult questions. But one thing I would caution lawyers to do is do not try to answer those questions with fear, because we are professions that are trained to be very skeptical of anything. you can throw like free diamond in front of you, and you still have counsel who would be like, you know, no, I don't want free diamond, right? So just be aware of that. As a profession, we have a tendency to be overly skeptical, and we have a tendency to be more resistant to change than other professions. Knowing that, then, you know, as long as we're not basing the discussion on those instincts, then we're fine. Like whatever place we come to is, I think it will be a much more sort of nuanced discussion than before. Excellent.
Well, I think we have come to the end of our panel. I would really, we went you know, a few minutes over the schedule, but there were sufficient questions, and there was sufficient interest, and the numbers have been maintained. I would like to thank every single person that has connected via this Zoom meeting, and I would like to thank again Eric, Isabel, and Preeti, and of course our friends from the ICDR and from GS. And you know, stay in touch. Keep on your masks on to everyone, and we'll be answering the questions that weren't answered. Most of them related to the existing tools in the AI, you know, via the ICDR or through other means. I would like to thank everyone in the name of Strategy and in the name of each one of the panelists. Thank you all, and have a wonderful rest of the day. Bye-bye.